Take your time and get settled before we start. I'm ready to proceed.
May it please the Court, my name is Justin Howard. I'm from the Public Interest Law Center of Florida State University College of Law, and I represent the appellant, Miguel Lorenzo, in this case. I'd like to reserve 3 minutes for rebuttal, please. I'm here today to ask this Court to reverse the Agency for Healthcare Administration's denial of 24/7 nursing care assistance to the appellant. The appellant suffered a near-drowning accident in May of '07 when he was just 17 months old, which has left him in a permanent vegetative state entirely reliant upon life support. He requires constant nasal and oral suctioning as well as constant supervision and care. This is because an emergency situation can happen in an instant and Miguel could die within minutes. Since his release from the hospital in July of '08 and until May of '09, a period of approximately 2 years, Miguel Lorenzo had been receiving uninterrupted 24/7 skilled nursing care from the appellee. The agency had the burden of proof in this case to prove that a reduction in Miguel Lorenzo's skilled nursing care was medically necessary.
There is a lot of argument in the brief over the term medically necessary. Isn't what we're really arguing about here the Florida Administrative Code 59G-1010, talking about private duty nursing services that are authorized to supplement care provided by parents and caregivers? Parents and caregivers must participate in providing care to the fullest extent possible. Training can be offered to parents and caregivers to enable them to provide care they can safely render. If I read the record here, I don't think anyone is really arguing that this person did not need round-the-clock, basically, medical care. It doesn't just come down to a question whether there's evidence to support that the parents could give some of this care.
Well, I think the evidence comes down to a few things. The first is that Miguel Lorenzo's father, his caretaker, has been trained to provide certain aspects of his care. The record does indicate that he was able to perform nasal and oral suctioning, and that he has an understanding and awareness of the type of medical equipment that keeps his son alive. But ultimately, he has never received emergency training. And in fact, in cases where emergency situations have happened in the past, and there have been several emergency situations, a nurse has always been there to provide the necessary care for Miguel and to protect his life. And furthermore, at the fair hearing, one of his nurses, Doletta McDonald, who has been one of his nurses for 2 years, testified that she did not believe that he could provide an hour of uninterrupted care because of Miguel's fragility as a patient and because an emergency situation could happen at any time. And I'd like to mention also...
But didn't they have several doctors testify that the father and the mother together could provide this level of care?
There is some indication from the record, from the testimony of Eleanor Littman, that they were trained to handle some emergency aspects of care before the patient was discharged. But ultimately, Miguel Lorenzo had been receiving and was deemed medically necessary to receive 24 hours of skilled nursing care. And you're right to say that 2 physician reviewers did say that 24-hour medical care was not medically necessary. However, in this particular case, Miguel Lorenzo's treating physician, Dr. Mitchell Samuels, did say that 24-hour care was medically necessary.
Okay, are we required to accept his treating physician over the other 2 physicians?
Well, this court has held in Snyder v. DCF, which has been adopted by the 3rd DCA in CF v. DCF, that the state must give considerable and substantial weight to the opinions of treating physicians.
What was the issue in the Snyder case?
The issue was for, I believe, personal care assistance. So it's a slightly different situation, but the principle is the same. And the court had held that,
And I may be thinking of a different case. Was Schneider the disability case?
yes, it was,
Determining disability, and then they say they give great weight in determining disability?
Snyder had held that considerable weight must be given to the treating physician, and the failure to do so must be accompanied by a showing of good cause. And in this case, if you look at the hearing officer's final order, you'll see that not only was there no showing of good cause, but there was really no showing of any cause at all. On pages 20...
Also in Snyder, though, to kind of add to Judge Wool's question, it appears we're fairly familiar with the five-step test. It appears the ALJ didn't properly apply that test.
Right, I agree, but I think that the holding and principle articulated in Snyder about the treating physician rule, which this court used and applied, and which was adopted by the third DCA and DCF and CFB DCF.
How would we ever weigh that then? If the rule is simply out there in the atmosphere somewhere that you have to give extra weight to the treating physician, how would the ALJ ever know when there was enough CSE to go the other way?
Well, I don't know that I'm not necessarily arguing that the ALJ must give extra weight. We're just arguing that he should give some weight, and that if he doesn't give any weight at all, that he should explain why. And that's part of the problem with his final order. In regard to the treating physician rule case, or instance rather, he doesn't give any reasons at all why Dr. Samuel's opinion should not be followed. And in this case, Dr. Samuel's opinion accounted for Miguel's medical condition and the level of care needed to ameliorate his symptoms, and his recommendation...
Do you know how there's a record reflect, or do you know how the 23 hours are being provided?
No, I do not. I know that they are continued to be provided now during the pendency of the appeal.
What I'm getting at is temporally. There doesn't have to be a 1-hour break. It could be two half-hour breaks at 7:30 in the morning and 7:30 in the evening, right? Still get him 23 hours?
I'm not sure.
The point I'm getting at is, I understand your argument. It's a passionate one. This is a very difficult case. But if you look at it in those terms, that it can be provided with half-hour breaks, it doesn't seem to me like it's that different than the nurse, going to the bathroom.
Well, even the nurse had testified that at the hearing that she didn't believe that Miguel could be left alone for any more than about 10 minutes. So still, he requires constant supervision.
Well, that gets back to Judge Wolf.
I think everybody agrees.
Yeah, and I'd also like to mention that cited in the final order as a finding of fact, although it's not really a finding of fact, because ultimately in this final order it's incredibly legally insufficient because of the fact that the hearing officer failed to make the required findings of fact and conclusions of law. And this court has noted in several cases the frequent need to reverse final orders that fail to sufficiently contain detailed findings of fact because they do not allow for effective and meaningful appellate review. And
I'm going to tell you, and you're doing a tremendous job here, but if we really literally treated these as Chapter 120 cases, the cost of Medicaid in this state would even be higher than the 40% of the budget it's currently consumed, be much higher. There has to be I'm suggesting to you, there has to be some room for practical application of this semi-formal process for Medicaid determination.
I agree, but at the same time, Rule 65-2.066, subsection 3 of the Florida Administrative Code governs the final orders issued by hearings officers in this case and requires, among other things, findings of fact and conclusions of law. And the Florida Supreme Court has held in Hardy v. City of Tarpon Springs that mere recitals of evidence do not satisfy the requirement of a statement of findings of fact.
And that's my whole point, though, and this is probably not something you prepared for. But my whole point is that if we were to treat these type of determinations, and we have a lot of systems of hearing officers in Florida other than the DOA ALJs, if we were to really hold their feet to the fire the way that y'all are understandably requesting us to do, then the cost of administering this program would just be phenomenally higher than it already is.
And
because they don't get pro bono attorneys on the state side.
Your point is well taken, but I would argue that the failure for the final orders to contain something for this court to actually review prejudices the rights of my client, and more importantly, really betrays the agency's failure to meet its burden of proof. And ultimately, you really just can't make a reasoned opinion based on this final order because, like I mentioned, it merely recites the documents and evidence and just describes the testimony of the various witnesses at the hearing.
And with regard to the three doctors, it recites their testimony, and then it said that he found, the hearing officer found Drs. Bruno and McCoy to be correct. I don't know if I'd use the word correct, but that seems to be saying that he found their testimony more persuasive than the testimony of Dr. Samuels and followed it. Yeah, that's kind of finding the fact, isn't it?
In one sense, but in the other sense, you're right. He says after careful consideration, and ultimately, in my opinion, it's really impossible to know how he reached that conclusion. In the preceding sentence, he says that Dr. Samuels, Miguel's treating physician, says that he requires 24-hour care, and in the next sentence, he says that the two treating physicians...
24-hour care by a nurse.
By a nurse,
okay,
correct.
I don't think he's
24-hour skilled nursing care.
That he needs 24-hour
Correct.
care. The issue is whether it has to be by a nurse or
Right.
whether the father can provide some portion.
Right. No, his recommendation was absolutely for 24-hour skilled nursing care. And in the very next sentence, he says that the two physician reviewers, Dr. Bruno and McCoy, do not believe that 24-hour skilled nursing care is correct. And I think that ultimately he should have articulated some basis for his decision other than after careful consideration. I think he needed to make at least some finding of good cause or really any cause at all as to why he found the way he did. And again, I ask this court to...
We haven't asked you a lot of factual questions, but I get that the evidence is undisputed now that your client is connected to the ventilator through his tracheotomy all the time.
Correct. Yes. He is not able to...
There's no attempt to wean anymore.
Correct. He is unable to be taken off the ventilator for any length of time. And presumably, in the record, as I mentioned, the CMS report indicated that he was able to be taken off the ventilator for some time, but he is not anymore. And presumably, the final order upholds that recommendation based on this fact, which is not supported by the evidence, and as such cannot constitute competent substantial evidence. And I would again just like this court to reverse the ACCA's decision for the reasons I stated previously. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Dwight Slater, and I represent the Agency for Healthcare Administration, the appellee in this matter. Now, I do believe that the Court's characterization of this situation is correct. No one is saying that ML doesn't need 24 hours of care.
Okay, stop right there. Because part of my problem is, the agency initially came in and said, well, the parents could do 2 hours of care a day. And if you have somebody that needs 24-hour care, they need suctioning, they need all these other things, part of the reason is that emergencies can happen very easily in this situation. How do you pick a number? Is it just based upon this guy only works 6 hours a day versus he works 2 hours a day? I'm not sure I'm coming across, but it seems to me it's almost like what the department's asking us, it's almost like a crapshoot. You could have picked any number here. What makes 22 any better than 23? 21 better than 23? 20 better than 23?
Well,
you see what I'm asking?
I do see what
Because an emergency could happen anytime. The care could happen anytime. So what are you basing that number on?
It's based on a number of factors, Your Honor, and it's primarily the way the program is designed. The Private Duty Nursing Services program was never designed to assume the role of primary caregiver. It's, as Judge Roberts stated, it's designed as a supplement to care provided by ML's parents. So 24/7 PDN services is by definition not supplementary. So there has to be a reduction over time, and that's what the rules call for, a reduction in hours over time.
But if they can do the suctioning, why 23 versus 18?
Well, the agency does take a number of factors into account when making those determinations. It's the number of hours the parents work. They provide hours for sleeping. It's never going to go down to 0 hours, or I won't say never, but it's not a situation where it's going to go down to 0 hours of care period.
So it's based on the amount of time the parents work. Is that an opinion that these doctors could give? I mean, it seems to me you have to make an evaluation of the free time that the parents have.
And
Now,
that-
what kind of evaluation is that?
That is the case, Your Honor, but I believe in this situation, it was primarily an incremental reduction in hours. So it went from 24 to 22 initially, but as was testified to at the hearing, that
Can you come in next week and say 20?
I believe next time this case comes up for review, the whole situation is reviewed anew. So,
18?
again, Your Honor, all of those factors are taken into account.
Well, tell me the standard. You know, it has to be subject to some kind of review. So tell me the standard that we're to use in determining how many hours you can cut.
Well, Your Honor, the 23-hour number, the figure that was arrived at was not an arbitrary figure. It was initially 22, and this was testified to at the hearing, it was raised back up to 23 to allow for an easier transition for the family. So those are the types of considerations that are brought into account.
Do we know in those 2 hours that he's not going to have an emergency?
Your Honor, in the past, there have been emergencies that have arisen, but even with the presence of a nurse, ML was taken to the emergency room, and that's what any other parent in the state would have to do, is take their child to the emergency room. And I don't mean to sound flippant, but that is something that needs to be taken into account. Even with the presence of a nurse, an emergency can arise, and the emergency room is...
Can the department say, and why can't they say, okay, he can work 8 hours, we'll give him 8 hours to sleep, but the other 8 hours, the parents have to give care?
I do believe the
Can the
agency...
department say that?
I do believe the agency can say that at some point, but I don't think the agency wants to say that at this point because, as I said, it's an incremental reduction in hours, and that's what the program is designed to be.
But it's not any less medically necessary. If the standard's medically necessary, is care for 18 hours any less or any more medically necessary than 23 hours?
The standard is medically necessary, but as I stated, the private duty nursing services program, it has a balancing. Hours can be reduced if the child's condition improves, and no one's arguing that in this case, or hours can be reduced if the parent's proficiency with his care increases. And I believe in this case, after 2 years, and there's competent substantial evidence in the record that shows that both of his parents, we're not only talking about ML's father, the testimony at the hearing was also that the mother visits 3 to 4 times a week, so she's also available to provide care.
That's kind of a perverse incentive, don't you think? You know, if the parents are more engaged and learn more, they get less services from the department.
Well, I don't know if I would characterize it as a perverse incentive, but I do see what the court is suggesting. The issue is, Your Honor, that there's only a finite number of hours that can be provided by the agency, and every hour of care that ML receives that isn't medically necessary is an hour of care that's not available to another child. So to the extent that his parents are able to perform these services, perform this care safely, they have to take responsibility, and that's what the rules call for. Parents have to
When you
participate.
make your next cut to 20, let's say, is that going to be based on the proficiency of the parents, or is that going to be based on you saying, well, we got to cut it back today?
I can't speak to what will happen in the future, but as the rules state, it will be based on the proficiency of the parents.
Okay, so what we're looking at is the proficiency of the parents.
That's
Their
what it is.
ability to handle a situation.
Yes, Your Honor, it's not an arbitrary reduction at every couple of months. It's
Okay,
as the
but we
skills
all agree
increase.
that they can come in and do the suctioning, they can do a couple of the other things that the nurses do. But I'm still having trouble tying that to a number of hours that can be reduced.
Well, and I think it's more than just the suctioning. They've been evaluated and evaluated by the home health agency, in this case, the Coastal Kids Home Health Agency, and they've both been deemed extremely competent in the vast majority of all of his care. So the reductions have to happen, and the first one has to be somewhere. And if we're starting at 24, 23 or 22 is the next logical step as we reduce it over time. And as I said, the program is designed to supplement, and parents are required to participate at the fullest extent possible. And 24/7 suggests that they aren't participating at all. If the court has no further questions on that issue.
I would like you to address the sufficiency of the order, his argument on that.
Yes, Your Honor. The ultimate issue in that area is whether there's enough for this court to review. And I do believe that there is enough in this final order for the court to make adequate judicial review. And Your Honor pointed out perfectly, I think the most glaring finding of fact was that the hearing officer found that Dr. Rocha McCoy and Dr. Bruno's opinion on the matter was correct. And that is a finding of fact that involves a weighing of evidence. He heard testimony and evidence regarding Dr. Samuels and these other two doctors, and he decided that Dr. Bruno and Dr. Rocha McCoy had the correct opinion. So that's obviously a weighing of the evidence. And the law only requires that the order contains finding of facts and conclusions of law. And this has both. Now, they may be mislabeled, but that's not controlling. And I think the other point, Your Honor, is that these hearing officers aren't lawyers, so the final order may not be written how I would write it or it may not be written how counsel would write it. But, you know, this was his best estimation of what a finding of fact is and what a conclusion of law is. And I think in total, the final order can be read to show the court how he reached this conclusion. So I think legal sufficiency is not an especially high bar generally, and I think this certainly meets it.
I guess one other question, I can go back on the record. How much did your doctors address the proficiency of the parents? Had they gone over it with them? I mean, what was their basis for determining the proficiency of the parents?
Well, there was a home visit. A nurse and a social worker go out and they interview the parents, and they, I guess, do a home visit or home assessment. And in the discussions with ML's father, and this is all cited in my brief, ML's father says very plainly that he's very well versed in all of ML's care and all of his medications. And they also based the decision on the Coastal Kids checklists, which are also on the record, which show that both parents are very well versed in all of the treatments that he has. Further, I think the fact that ML lives at home and is not institutionalized in the hospital certainly suggests at least a measure of stability. And beyond that, I think all of those things go into play in what the doctors assess. If there are no other questions on that point, I would like to address the treating physician issue. I think appellant is asking the court to impose a rule on the agency that says that the agency must automatically afford substantial deference to a treating physician. There's no such rule in Florida. The appellant's basing that on the Snyder case from this DCA, and I think that case has since been undercut by the U.S. Supreme Court in the Black and Decker case that's cited in my brief. In the Black and Decker case, the U.S. Supreme Court essentially holds that the courts have no authority to impose a rule requiring agencies afford special deference to a treating physician, nor do courts have the authority to require an agency or impose upon the agency a burden of explanation when the agency does not agree with the treating physician. And courts don't have the authority to do that absent some provision, some statute-based provision or rule-based provision in the law. There's no such provision in Florida law. There's no such provision in federal Medicaid law. In fact, Florida law states exactly the opposite in our handbooks, which are adopted and incorporated by reference in the statutes. It says that just because a treating physician prescribes a certain treatment or service doesn't make it medically necessary. So we've essentially negated any sort of treating physician rule in Florida. If there are no further questions, the agency would ask that the court affirm the decision below, and we rest on our briefs. Thank you.
I just have a few comments. Judge Kahn, you're absolutely right. The figure of 22 hours from 23 hours to 24 hours is completely arbitrary. In 6 months, when there is another certification period, the agency could absolutely come back and drop it to 20 hours to 15 hours. There's just no telling how the agency will drop the hours, but they certainly can. And the idea of dropping it from 23 to 22 to ease the transition, easing the transition, as nice as that is, isn't really part of the medical necessity inquiry either. And in terms of Miguel Lorenzo's father not participating to the fullest extent possible, the record indicates that he in fact does. When he's not at work, which he is full-time and he's on call 24/7, when he's at home, he spends his time managing and arranging Miguel's doctor's appointments, as well as really participating in all aspects of Miguel's care when he can, aside from the emergency situations that arise. Now, in terms of the treating physician rule and why it shouldn't be applied, ACCA basically makes two arguments. One is that Snyder is simply wrongly decided, and two is that Black and Decker overrules Snyder. First of all, no matter how wrongly decided they believe Snyder to be,
Let me suggest to you that Snyder and CF, the third district case, do talk about the treating doctor rule, but they also have other reasons I would suggest for reversing. And here's the concern that I have. If we were to say, well, we're going to do what the Snyder court maybe in your view did and adopt the treating doctor rule, it seems like that would encourage the ALJ to simply say, although having given additional weight to the treating physician and the orders of the treating physician, I nevertheless, and we'd be encouraging basically a lack of forthrightness, it seems like, if we did that. What does that accomplish?
well, I think that, the opposing counsel had mentioned that the home health coverage and limitations handbook includes language about just because the fact that a provider has prescribed a certain good or care does not make it medically necessary. And I think that language is consistent with Snyder, and I think it's consistent
What I'm
with Black and
suggesting
Decker.
to you is a matter of procedure, a matter of public expense, is that if we were to do that and were to reaffirm the rule, in, if you can call it a rule, in Snyder and in the third district case, wouldn't that simply be setting up these hearing officers to simply say, we start off with a presumption that the treating physician's orders are correct. Nevertheless, we find that the substantial evidence in this case militates the other way. I don't see what that accomplishes in the long run.
Well, I'm out of time, but if I can answer your question.
Yeah.
I see your point, and I think that there really should be the presumption that the treating physician rule is the place to start. However, built into the treating physician rule, into the holding in Snyder, is the fact that, if there is some good cause not to follow the treating physician rule, then that's perfectly reasonable not to do so. But in this case particularly, there just simply wasn't any cause shown not to follow the treating physician rule.
Okay, thank you.
Thank you.
I want to thank both counsel for excellent argument today. There will be no further cases in front of the court.